the 40% of you who have still not subscribed to the Ethicsverse, welcome to the coolest place to be every Tuesday at noon Eastern. If you think fixing our healthcare workplaces can fix our world, I got a real treat for you today. We're going to be diving deep on DOJ enforcement in the healthcare space. We got the one and only team here. You guys are going to absolutely love them. Let me pull them up on the screen. We have Leigha Simonton and the one and only Brad Hogan. How's it going, guys?
Good. Scott Hogan.
Scott Hogan.
Brad,
oh my gosh, I'm so sorry. My eyes are not working. Sorry, Scott. That was a little trick there for you. Okay, so I'm going to dive through a couple of quick announcements here. And as we get going, please drop your LinkedIn URL in the chat because your network is your net worth. Neither are big enough. So we're going to be talking about federal investigations and enforcements in 2025. Drop those LinkedIn URLs in the chat and connect with one person today. We're going to be, of course, giving away books. We're giving away credits. So if you're with HRCI or SHRM or CCB, this is the place to be. And we're giving away 5 copies of one of my all-time favorite books from the one and only Christian Hunt called Humanizing Rules. So if you have not gotten this book yet, now is the time to do it. So also wanted to let you guys know that next week in October 14th and 15th in Nashville, be there or be square at the Opal Transforming Healthcare Conference. I'm going to be up there talking with Reed Blackman and Camille Howard. We're going to be talking about ethics at the edge, how to build better trust and governance into healthcare innovation. So if you are in Nashville or want to come to Nashville, dust off those cowboy boots, use code Ethico50 to come in at 50% off because I love you. Let's get some massive emojis going though right now. We're only at 300. I'm trying to kind of scratch my head a little bit on that. We're going to be doing, you asked, it's coming. We're going to be doing an entire session on the Enneagram and how leveraging that can make you a better compliance officer by learning your strengths and tuning into the strengths and weaknesses of those people around you, whether they're counterparts in other departments or folks on your team. So much of our job is really kind of magnifying our superpowers, and we're going to be diving into that. So in prep for that, hit this QR code here, and you can do the Enneagram quiz. It'll assess what your type is and give you some tips on how you can really lean into some of those superpowers. So much of our job, and we're going to be talking about this, at least in a sort of tangential way, so much of our job is really contingent on the extent to which we're able to crowdsource that risk intelligence from our organization. Compliance is a people business at the end of the day. And when we can't get the participation and the engagement of the workforce, then we don't know what to work on. We don't know where to make the right bets with our time. So we have an employee engagement package that really helps create more touch points with your organization to drive better risk intelligence into that central risk brain that you manage and from which you deduce what kind of bets you need to make with your time and your resources. So we have a whole list of solutions that come into this outcome. The world's best issue intake and hotline system, the case management system that helps you close your cases twice as fast, disclosures built directly into that tool, built-in remediation plans so you can have your many times an investigation is not the end of something, it's the start of something, and we can show effectiveness by showing that there's consistent remediation of issues, whether they're different categories or different severity types. So having that built in, and then exit and stay interviews, which we're calling employee lifecycle touch points. You know, the number one thing that prevents somebody from speaking up in the organization is usually a fear of retaliation, which leaves a lot of the risk intelligence we get, being sort of pushed into us. When we can pull some of that information in on a targeted way, we can get a lot more, our finger on the pulse to a much greater degree. And then, of course, an employee portal that opens that up for everyone. So if you're interested in that, which you should be, 25% off for all my Ethicuties through Q4. So hit that demo if you'd like to check that out. Okay, with that, how is that? Round of applause for my announcements got through in record time. Okay, so we have the team here. You may recognize these guys from our comic book that we've been in. And if you haven't read that comic book, then you might recognize them from the most successful Ethicsverse Day in the world, the biggest ethics event that we had in July. These guys were on our highly reviewed DOJ session, really talking about enforcement actions and what it really takes to build an effective program that's going to withstand outside scrutiny. So we have Leigha Simonton and the one and only Scott Hogan. Again, sorry for that, Scott. I forgot my glasses. We got Scott and Leigha, and we're going to be talking through today a lot of topics that I think a lot of us are kind of asking about on kind of an ongoing basis, and we're going to be talking about it from the healthcare landscape perspective. So I want to get started. Leigha, why don't I start with you? There's been a lot of talk about the current administration's emphasis on healthcare fraud and enforcement. We've had high-profile investigations with United Healthcare and so forth. How do you think the DOJ's approach to healthcare compliance has evolved, and what do you think compliance officers should really be looking out for right now?
Right. Thanks so much, Nick, for having us back on. It was so much fun when we were here in July that we were really excited to reprise our little group. And one of the inspirations that we had, that Scott and I had for this topic, was that after we appeared on the July Ethicsverse Day, we got a lot of requests to connect on LinkedIn with specifically healthcare compliance people. And that makes a lot of sense given, as we'll get into, the current administration's priorities. And so we thought, and our background is very strong in healthcare compliance issues, that we thought it would be good to have an episode devoted entirely to that topic. So my background, in the split second, is that I was in the DOJ for 20 years, specifically at the U.S. Attorney's Office for the Northern District of Texas, which is based in Dallas, but covers 100 counties in North Texas. The last 2 years, I was the U.S. attorney of that district, which meant I ran the entire district. I was presidentially appointed. So I got to see everything that happened in our district and also work with Main Justice on a lot of things, including healthcare. So with that in mind, I totally can see the differences, the changing priorities between the last administration and this administration, because I only got out of DOJ in January. And I wanted to highlight some of these things because they really set the stage for the rest of our discussion today. So everyone knows, you've all heard this, that one of the new administration's priorities is to combat waste, fraud, and abuse. One of the ways it is doing that is focusing more than I think ever before any previous administration on healthcare fraud of various types. So I'm going to highlight a few ways in which this administration is focusing even more intensely on healthcare than it has before. The first is that they very soon after the administration took over, only a few months, in June, announced a healthcare fraud takedown. So a takedown is when you bring a lot of indictments, a lot of charges at once against a specific group or type of crime. And I had not heard of a healthcare fraud takedown before. This one was a huge press release and a huge subject of national news because they advertised that they took down 324 defendants criminally. Some of them were physicians, some were other professionals in the healthcare field, some were company executives. And I'm going to get into it a little bit about how broad that net was, because it was much broader than you would assume it would be. So that is the big push that they did initially to show they were serious about combating what they see as healthcare fraud. In that takedown, there were 50 U.S. attorneys' offices involved, and those are basically the DOJ offices in all of the states. Some states like Texas have multiple U.S. attorneys' offices because it's so big. So that means that over half of the U.S. attorneys' offices in the country, there are 94 in the country, were involved in that single takedown. That is a lot of agents at the various law enforcement agencies and a lot of prosecutors who are working on these cases. There were also 12 state attorney general's offices involved. So they worked in collaboration with state actors to take these people down. So in addition to that big push, there are also certain elements of the administration that are getting more, I would say, resources than before and expanding their reach. One is there's a Medicaid fraud control unit. There are 19 states involved. That actually was pre-existing from the prior administration. But as part of that, there's also civil settlements that have been reached. And those include, and Scott can talk more about this later because his background is in civil government medical fraud. But there were lots of civil settlements that were reached with different entities and a lot of money that's going back to the government through things like that task force. Also, compliance with DEA regulations has really grown in terms of an enforcement area over the last several years. Again, Scott will talk about that because that is totally something that he did a lot of in our office. The press release in June highlighted that over the last few months, DEA charged 93 administrative cases seeking the revocation of pharmacies, medical practitioners, and companies who had authority to handle controlled substances. Then we have the ordinary healthcare fraud strike force, which is kind of like Medicare fraud strike force, but different in that it encapsulates all kinds of different healthcare fraud. Those are throughout the country, and this administration added a new one for the District of Massachusetts. So it has expanded the reach of those investigatory and prosecutor entities. In our office, we had a strike force, and they're run by Main Justice, but they're embedded with the U.S. Attorney's offices, and they use a lot of the same agencies, federal agencies here, like the FBI, to investigate alleged healthcare fraud. And so that basically doubles the number of prosecutors in an office who are looking at healthcare fraud. But in addition to those strike forces, some U.S. attorneys' offices have added standalone healthcare fraud units in their offices. So we did not have a standalone unit, but now they were cropping up in a lot of U.S. attorneys' offices. So now you have a dedicated group of prosecutors who are assistant U.S. attorneys, not Main Justice people, who are looking specifically at healthcare fraud, and they are prioritizing that over other kinds of fraud because that dovetails with the administration's theme of waste, fraud, and abuse. The last thing I'm going to mention is that another thing that this administration has focused on is the lack of adequate cybersecurity controls on healthcare information. So there recently was a civil settlement reached with a company called Illumina Inc. And it concerned allegations that that company had lax cybersecurity controls over things like genomic sequencing data and other sort of medical or scientific information. And they had to pay $9.8 million, so almost $10 million to the federal government because of those controls. Yet another thing that people have to be aware of in this space if they are working in compliance.
So to boil it down, and Scott, I'll come to you. I'd love your take on this question of, what should a compliance officer be watching out for in the context of this evolution that Leigha just kind of walked us through. Just to kind of boil it down, though, there seems to be like a massive expansion and a sort of credible increased focus on fraud detection and fraud, mitigation in healthcare in specific.
I think that's right, and it is great to be here with you again, Nick. But I think you hit the nail on the head. I think there is a focus because of what is the perceived return on investment, right? The healthcare industry is such a massive part of our economy now, and it's part of such a massive part of the government's budget. Whether it's through Medicare spending, a lot of people forget about the TRICARE spending, Medicaid as well in partnerships with the states. That all of that is such a huge part of government spending, and it's big headlines, and political favor comes from trying to espouse the great return of monies that have been inappropriately taken in the healthcare system. So yes, that Leigha's exactly right. There's an expansion in terms of how much it's being talked about. Especially. A lot of this has been kind of evolving over the last several years, but this administration is talking about it more. It's in the headlines a lot, and I think that's probably good for everyone to be aware of. I think what we're going to continue to see, right, is more into the cyber world in particular. I think Leigha mentioned also just like into other areas that perhaps don't get as much media attention, like DEA oversight, controlled substances regulations, things along those lines. That has always been there. Folks that work in those areas, they know it's there, but I don't know that it's been talked about in the headlines and throughout industry publications as much as I think this administration is trying to do now. So I think we're going to continue to see that push for attention to be given to all of these different enforcement efforts. And I think the cyber settlement that Leigha mentioned, I think that's huge, and I think it's going to continue to be an issue. We all know about HIPAA. We all know about our requirements under HIPAA, but these requirements for controls over data collection, and I've heard it said many times, and Nick, you may have heard it. Every company is a data collection company, right? If they exist, they're collecting data, and that is a real focus of the this administration, making sure that those at least proper controls are in place, because we all know that ransomware and cyber attacks are now unfortunately just a part of our everyday lives.
So I heard this feedback on the last session you guys did, which have I talked about how much people loved it? People can't stop talking about that DOJ session.
So that's great.
Thousands of emoji reactions.
Awesome.
I got awesome, great feedback about it. But the kind of consistent through line in the feedback that I got was how practical the advice was, how practical the perspective was. This is not some kind of like academic discussion. It's really, you guys do a great job of sort of bringing these sort of concepts down to earth, and how folks can kind of really take advantage of these developments at the sort of federal level. Kind of take advantage of those developments internally to get more resources, or get a brighter light shined on these functions that we all manage that are increasingly more important. So I want to talk a little bit about that in the context of this evolution, this increased focus on healthcare, on fraud in the healthcare system. How do you think a compliance team can really leverage these developments to argue for, or to demonstrate the need for more resources, or more buy-in, or more access to really kind of help take their program to that next level? Why don't we start with you, Leigha?
So we're going to probably even talk about this later, Nick, but the advice I want to give everyone right now is that the best defense is a good offense. Thinking about these things before you get a civil investigative demand, before you get some inquiry from a state attorney general, before you get a subpoena from the FBI. That is when you need to be thinking about this. And it's very important to reevaluate your compliance plan and your internal investigation plan to reorient it towards this administration's priorities, which also dovetail with the priorities of the state attorney generals. So if you don't have a cybersecurity section, you need one when it comes to any health or scientific information that you have in your company. And also, one thing I want to highlight here is it's not just companies who need this program if you are dealing with government money. It's not just money coming from Medicare or Medicaid. It's also, and this is a big expansion, Nick, from prior administration, a much bigger push on private insurer disputes with healthcare providers. We actually are representing someone in a case like that currently. And what I can tell you about it is, how we see it is it's a private contract dispute about whether an insurance company should pay certain things that were billed, that were done, they were services provided, or whether the provider of the services coded it wrong. And this has been a subject between these two entities for years. And it resulted in civil proceedings, and now, shockingly, criminal proceedings against the executives who were involved on the healthcare side.
Wow.
And so how it originated is there are these things called SIUs, special investigation units, that insurance companies have. I'm sure I'm not telling people anything they don't know. But those entities are specifically tasked with ferreting out things that seem abnormal, and not just having the insurance company address them with those they contract with, but also referring certain things to law enforcement to be investigated. And that is what happened here. So your compliance program should focus on, what do we do if we are in a contractual dispute with something like an insurer, and maybe they're claiming that something was done wrong or billed wrong. You should have a think about how you can structure your program and your response to deal with that possibility. How to bring in counsel like us or like someone else who has that expertise to deal with them, so that it doesn't turn into something crazy like a criminal investigation and indictment.
That's great. That's something very practical that we can kind of start thinking about right now. That's
Nick,
obviously an expansion beyond what people expected, right? That sort of criminal angle. And so as if we're navigating a ship, we're not just kind of charting to the stars. We also have to keep in mind like the weather patterns as those weather patterns are changing, and make sure that we're helping to guide the ship that is our organization, around some of these storms. And I think there's a lot of signals that you've just sort of alluded to, both of you, over the last couple of minutes, that we can take some hints from and kind of plan for. Sorry, Scott, what were you going to say?
Well, no, just in terms of what compliance officers can do to help manage that organizational fear, anxiety, right? Knowing their processes inside and out is huge, right? For the C-suite, the unknown is way scarier than the known.
Totally.
So if you can be that voice of calm, your processes, the protections that are in place, the likely people that are going to have relevant information to an inquiry. What documents should be there or that you don't keep. When you're able to provide that to your C-suite or your legal office, that provides that expertise gives such value to you and to your organization that is probably beyond what they realized a compliance department can do.
Yeah, I think to that point, I mean, I love that point. Our job is not to sort of show that everything's fine. Our job is to, again, be that Sherpa or be that trusted advisor within the organization on the things that are within our purview to like de-risk the company, to make us, drive down that road more efficiently. And I think to your point, when we know our process and we know kind of the lay of the land to a deeper degree, it becomes easier to kind of point out like existing flaws in the process or weaknesses in the process or things, to kind of substantiate what change you might need to make, what some of those weak points are that require attention in this new kind of landscape that we find ourselves in. We have to develop that muscle, that confidence to be exactly what you just talked about, Scott, to shine a light on sort of gaps in the process, because like to any extent that a process is sort of articulated on some piece of paper with a bunch of, letters that are adding up to, words that are adding up to paragraphs, the world is changing all the time. So, the sustainability of any process, at least come on a long enough timeline, kind of comes into question. And it's our job to make sure that the biggest things, the biggest risks are being addressed and, adapted for, you know what I mean?
Absolutely. If your compliance plan today mirrors what it was 20 years ago, you're lacking severely, right?
Totally. And even 2 years ago, in light of everything you guys just talked about,
Yes.
Yeah. A couple of great questions here. I want to go ahead, please, Leigha. No, go ahead.
Oh, all I was going to say is I do think it's really helpful when people are thinking about how to reorient their compliance plans to think about, to bring in other people from the outside to look at it and to say, actually, I would add this, because you may not see everything, but people who've recently been in DOJ will see it and they will point those things out, because they're going to be different risks for every company. One company might not have a key TAM or False Claims Act risk, but they might have a big cybersecurity risk. And so I think that individualized risk assessment so that you can build up your compliance plan is important. And the second thing I want to emphasize is your internal investigation plan is just as important as your compliance plan, because it needs to be streamlined so that when there are irregularities, they are brought in a central funnel and they're not piecemeal brought to different people. So there can be coordination on it. It gets to the right people and it's handled consistently with other similar types of things that happen in an organization.
So there's something really key, there's a lot key in what you just said, but that consistent application of our investigation protocols or the consistent remediation, those, I would imagine, those are the easiest things to point to validate whether someone's program is like moving towards effectiveness or kind of staying on the shelf as like a stale sort of reactionary program. So
yes,
there's a lot in that. I think there's a lot of time spent by compliance teams like double checking work across investigators to say like, are we following this process? Are our protocols and are our guardrails that we've, at least kind of articulated in our policy document or in our procedures document, are those actually being followed? And then ultimately on the remediation side, are we consistently applying the same remediation efforts in a consistent way? And are we even looking at those remediation plans periodically to make sure that they're still adhering to the new scope of things or the new regulations in a different state or things like that? But, a lot of what we talk about on the Ethicsverse is like how we can drive more effectiveness in our programs. And I think part of it starts with that mentality and that mindset that like, I need to stack the deck in my favor so that if this potentiality becomes an eventuality, then like my ducks are in a row and I've done that sort of pre-work instead of like living in that sort of scrambling mode. So Kelly has this great question. Kelly, thanks for this. Did you have something else to say on that, Leigha, or you want me to ask this question?
Oh, all I was going to say is one reason that's important to Nick is that you want to be able to be in the best position to jump on something fast, because this administration, another point that differentiates it from prior administrations is it gives a lot more cover to self-reporting, to entities that self-report, if they do it within a certain amount of time of when a whistleblower comes to them. So you have a little bit of a grace period, but not much. And so it's a race, to report between you and the whistleblower. And you want to be able to have that information before the whistleblower goes to the outside and to the government entity to decide whether self-disclosure is the right thing.
We've seen we did a couple episodes over the last, couple of quarters about whistleblowers, and we had some whistleblower attorneys on. And across these episodes, sort of the through line or the consistent thing that I heard over and over again was like, nobody is going outside of the organization to be an external whistleblower unless they've tried internally first a couple of times.
That's right.
It doesn't seem like people are like, oh, this is a cash grab, I'm going to go try to do this. Like that is few and far between. The overwhelming majority of external whistleblowers really have been at their wits' end, is at least kind of how it's been painted for me. They're at their wits' end when they're kind of going outside the organization. So I think to put ourselves, to kind of put your advice into practice, to put ourselves in a situation where we're able to take care of that sort of closing window for self-reporting, should somebody go outside the organization, I think it really kind of starts with our existing whistleblower program right now. Yes. Are we promoting it? Are we addressing the sort of elephant in the room, which is retaliation, right? Like half of the people, based on that ECI report that I reference a lot, half of the people that spoke up faced actual retribution. So there's some it's probably safe to assume that there's some, kind of retaliation issue inside your organization. To the extent anything above zero is a problem, there's probably something above zero inside your organization. So that focus on the retaliation piece, really kind of conveying a credible heart for the whistleblower. And then just that basic blocking and tackling of thanking someone for following up with them at certain touch points, following up with them after their case is closed to make sure that they know that your commitment to, stamping out retaliation is real. Those can create a lot more opportunities for us to like ultimately prevent, finding ourselves in a situation where we're, scrambling, quote unquote, to take advantage of that closing window.
Yeah, exactly.
All right, Kelly's question. Round of applause for Kelly's question, because I've been trying to ask it for a couple minutes, but we just keep going to too many good places here. So Kelly asks, do you believe the focus on reducing FWA is going to translate in a continuation of publication of the OIG compliance documents for these specific healthcare areas like labs, SNFs, et cetera?
I'm going to let Scott handle that one because he has done.
She sends you all the hard questions, Scott.
I know it. That's okay. I think they're going to. I think they're going to try. I think that every administration sets out to publish a lot more publications. Put out a lot more publications that addresses specific areas. But I think this administration, it might have an even larger challenge in accomplishing that because of the amount of people that are leaving the government, whether by choice or whether by force, right? And so expertise leaves, especially specific subject matter expertise. They end up having to start over. And then things like publication of compliance documents and guidance. It's one of those things that ends up just being pushed down the to-do list organizationally. And so while I think they had hoped that it was going to increase the amount of publication compliance documents that OIG and others would put out, I'm not sure that they're going to be able to accomplish that, to be honest with you.
All right, I want to kind of talk a little bit now about investigation strategy and like timeline expectations. So how do you think compliance officers can manage the organizational anxiety and the operational continuity when facing the uncertainty that inevitably comes along with a DOJ investigation. That may go quiet during extensive documentation phases. So I'm asking, like, how do we navigate through that, and how do we anticipate some of that anxiety that's going to bubble up between, this, like everything else, is kind of a hurry up and wait game, panic, okay, and then you're just like in this kind of blackout period. How can we better kind of navigate through that? Why don't we start with you, Leigha, and then we'll go to you, Scott.
Yeah, these types of things, and the most prominent example right now, Nick, is United Healthcare. There is a civil and criminal investigation going on to them. So we call that parallel proceedings or parallel investigations. So they are led by two different teams, one on the civil side, one on the criminal side. I kind of come from the criminal wheelhouse, and Scott led a lot of that on the civil side. And so they sort of move together, but they also can branch off and start to move separately. But you're not going to know for a long time. It takes a long time to gather that evidence and really understand what it means. And these things take a lot of time. Scott, do you know about what the average was when you did the civil side of things in terms of how long it took, even before, the civil part is unsealed, if it's a key tam, for example?
Mm-hmm. Yeah, if you're just having a civil case, you're looking at years, most likely. I would say most of our investigations wrapped up in about 2 to 2.5 years. If you had a criminal component that went along with it, that could slow the process down. And so you could be looking at somewhere in 3 to 3.5 years. Now, that's assuming things get closed up pretty quickly at the end. If you add litigation to it, whether it's with a relator or with the government, then you can tack on easily another 1.5 to 2 years for this thing to work through the courts, unfortunately.
So, I think in those types of situations, people are going to be looking to us inside the organization as like the lighthouse in the storm. They're going to be looking to us to hey, should we be panicked? Should we not be panicked? And I think us having some understanding or some basis for the expectations, at least in ourselves, makes it a lot easier to manage some of that organizational anxiety that comes along with one of these lengthy investigations. So I want to talk, though, about some strategic considerations that drive DOJ's decision-making process. Like, how do they decide when to narrow an investigation scope or expand it? And how do you think, a compliance team can prepare for potential trajectories? And again, some of this might be in the context of an investigation that's not even happening. We're just trying to kind of keep our, we want to keep our house in order so that should something happen, we have our things dialed in and so forth. How can we kind of think about that scope issue? And how can we think about, kind of preparing, doing that pre-work prior to something happening?
Yeah.
So there's a lot to that question, but
I pack it in, so you can take this any way you want, Scott.
There's like 12 questions inside that one question. But so generally, each investigation and how their decision making is going to occur is driven by the facts of that specific case, right? Or that specific inquiry. And what they're going to do is they're going to follow the lead, each lead that pops up where they think there's potential liability, whether it's civil or criminal. They're going to follow that lead until it reaches the end of that lead, right? And that determination at the end could be a positive or a negative organizationally. And that's on the criminal side and on the civil side. So what does it mean to follow that lead? Well, that's additional document requests coming to the organization. That's additional witness interviews. It's potential grand jury testimony. It's additional meetings with outside counsel, right? They're going to pull, assuming that they can from a time perspective, they don't have a statute of limitations issue or a key tam that's coming out from under seal. They're going to pull on each lead until it reaches its natural conclusion. Yeah. So one of the things that I think organizationally you have to advise your leadership on is that this is going to take time and there is not a quick fix. The DOJ does not, let's say you have a key tam, or even if it's not a key tam, the DOJ does not settle cases in like a cost of doing business or a nuisance value. Right. They do not settle civil cases that way. So it's going to have to be a principled resolution based on any amounts that have been paid to the organization or the provider. That also just takes additional time to try to unfold. And the DOJ is not just going to take your word for it. they're going to go validate everything that you're telling them to try to make themselves confident that that is the right outcome. And the same is true on the criminal side. They're going to make their own determinations. They're not going to let you just throw someone under the bus, so to speak, and hope to button things up from an organizational perspective. So unfortunately, it's going to be largely out of your control in terms of when those determinations are going to be made. However, I do think when you're able to provide that kind of insight to your leadership of this is our process, these are our people, these are issues that we think we may have some vulnerabilities on, this is how we think this investigation is going to unfold, I think that's going to provide confidence to your leadership that you have a pretty good idea of where this thing is headed and what type of vulnerabilities the organization may have.
And I will add to that, the more you can sort of play things out on the front end, the more it'll ease everyone's anxiety, and the more you actually can come up with your own game plan and be proactive instead of reactive. An example of that is if you get a civil investigative demand, which we would issue all the time. As U.S. Attorney, I sign them. Scott would supervise the writing of them. There's a memo that goes along with it that justifies why the U.S. Attorney should send that out. And it's usually concerning to companies when they get it. But I hear a lot after the fact, way after the fact, if someone's gotten what we call a CID, and they'll say, well, I just gave them the documents and I just hope that's it and I never hear from them again. And they never brought in outside counsel. They never brought in someone like us from DOJ who understands what that means and why they're asking for those documents, where it could go from here. Right. They just want it to go away. And it's like they imagine that it'll just go away. Typically, when a U.S. attorney sends out a civil investigative demand, it is not something that's going to go away. It is an active investigation into something. And, the best posture you can have is bringing in someone who understands how that process works to understand what is happening. And that can also lead you to investigate something within your own company that relates to that. So you can come up with the nucleus of facts that is important, possibly even later cooperating with the government, offering information that often leads to a much better outcome than if you resist. So we always advise, you might want to resist cooperating. That's just not good with the government. They'll never run out of money to pay their employees to continue the investigation.
It sounds like, it's kind of on us to kind of bet which way an investigation is going to go. And we need to kind of understand that an investigation is only going to sort of be closed, or they're going to be pursuing things based on sort of claims that are made and whether those claims can be validated. So if we can kind of think through what are our vulnerabilities given our business, given the controls we have in place, and if something went wrong, what kind of claims would the investigator be looking for to close the case and say there's not an issue here? From that, you can start to think back on backward from that on what claims would I need to be able to make? And then what evidence would I need behind those claims in order to validate it? And I think to the extent that the evidence bucket behind a certain claim is empty, well, those are some hints on where we might need to look, or at least be able to document and say, I don't need to put anything here because this is not a real risk for us, or this is my control sort of compensate for the inherent risk. But I think just spending a little time, again, a lot of what I'm saying is easier said than done because we all tend to spend most of our time in that sort of, the Eisenhower quadrant that's high importance, high urgency. But if we can spend a little time in the low urgency, high importance area, it really can, at a bird's eye view, give us some places that we need to start kind of bolstering our evidence or bolstering our validatable sort of data points behind whatever claims that folks are going to be looking for. Do you think that's a fine framework that we can start to employ to kind of find the holes in the hull?
I think that's a very good way to put it. And I think one of the crucial components of that is knowing your business areas, right, to the full extent you can. If you are unclear or you don't know at all kind of where the intersections are between regulatory vulnerabilities, criminal, civil vulnerabilities, and your businesses, then you're at a loss from the beginning. And you're trying to learn as investigators are trying to learn, which never instills confidence in anyone when you walk in the room and you're as lost as everyone else is. So to the extent you can try to learn those business areas, have lunch with business area leaders, try to understand where they are, what's going on in their area, concerns that they have. They tend to know, they may not know the details, but they tend to know enough to be able to say, yeah, that regulation's kind of weird. That's impacting us a little bit. Or I'm concerned how that might impact us. Or, this guy's off and we've got this marketing plan and I know it can look like a kickback, but I don't think it is. So I think we're good, right? Those types of things can be flags for folks to know areas to really start digging into harder.
So what are some of the typical timeline milestones from initial CID or subpoena through resolution? And how do you think compliance officers can use these to set board and executive expectations? You kind of talked about all in, it takes 2.5 years. It might be a little bit longer if there's a civil component that's tied to it or a criminal component like extension. Are there any sort of like high level guideposts that we can share?
I don't know of many because it's all so determined by the facts, right? And it could be, and I also want to make sure folks understand, you could get a CID or a grand jury subpoena and not actually be the target that the investigation is geared towards, right? So it's not always a panic time, to say the least. I would say more often than not, it is, especially if you're getting a CID, you are kind of being focused on and looked at, but it's not determinative of any outcome. But I would say, from an initial CID, from a document production, if you're a large organization, it's going to be a rolling production of documents, right? Which is going to take several months for the counsel to pull together and produce. If there's follow-up interviews, things like that, you're going to have a good idea of where things are going, I would say within 8 to 12 months as to whether or not you think this is going to become an even larger issue or if it's going to kind of close up for you. Like I said, the larger the organization, the more documents that are unfolding, the more counsel is having to kind of call and produce things, review and produce things, the more that timeline extends out.
Okay. So I want to pivot a little bit into coordination challenges and some practical implications. So, when there's an audit or when there's an investigation, it's not like our regular day jobs, stop. There's this like extra job now that we have in sort of coordinating and providing documentation and so forth. So I want to talk a little bit about some strategies to kind of manage that. And how do you think coordination limitations between civil and criminal investigation teams can affect an organization's response strategy? Is response strategy even something to be considering, or is it just there's no response strategy other than trying to be like good faith and helpful? Like, how do we think about that sort of response strategy, if any, and how do we kind of manage through, ensuring effective engagement with these outside parties? Let's start with you, Leigha.
So I think speed is of the essence, and the problem with doing it on the company side, digging in, doing the documents or investigation, document collection or investigation, is it is outside of people's day job. And we have seen instances in which people have, there's a big lag. And oftentimes the people who are tasked with doing it are not attorneys or are not sort of affiliated with legal departments. They're just, people who are employed in whatever aspect of the company has the issue. And they might not understand exactly, you'll give them sort of directions, but they may not understand exactly what they need to produce. And they're trying to do it on nights and weekends. And it's kind of a drip, 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 which is not effective. So one strategy that we have recommended before is to, if you're engaging outside counsel, just get ask for an associate. They're cheap compared to partners, and have an associate sort of help manage that document collection because they know what to look for, and it can be their job while you have the employees actually doing their day jobs, and they will be collaborating with them, but it'll be a lot more organized and end up being quicker if someone's kind of from the outside can jump in and help with it. But Scott probably has a lot of other good ideas.
I don't know that any of them are good, but I have some thoughts. So I think so much of it is going to depend on what the investigation looks like. And I know that's what every lawyer says and every person hates to hear. Oh, it depends. But it actually does depend on what that investigation looks like, right? But if you have a situation, we'll use the United announcement as an example where they've come forth and said there's a civil and a criminal investigation. The strategy that goes into how to deal with that is going to come from outside counsel, legal department, and then flow through the organization, right? And so the determination has to be made, okay, well, are we engaging with one side of the house and not the other? Grand jury information can't be shared from criminal investigators to civil investigators unless there's what's called a Rule 6E order that's put into place. So you may be producing documents responsive to a grand jury subpoena on the one side, and you may have to turn around and produce the exact same documents to the civil side. And in fact, you'll see that happen at times where a grand jury subpoena will almost mirror a CID that comes out. So that strategy has to be almost unified from the beginning in order for it to be most effective. And your counsel has to understand what your processes are and your businesses. So that's where you can play a real pivotal role in making that as efficient in terms of how you're responding and as effective in terms of strategies that will work versus things that outside counsel may suggest that from the inside, that's a bad idea. We have some real weaknesses here. We should avoid going down that road.
And is how much of that strategy is kind of a function of the extent to which we understand what they're going for or what they're looking for? Because let me just kind of give you a corollary. In audit, in financial statement audits or in due diligence for an M&A deal, there's always a massive document request list. And each of those items are meant to provide some data to validate a specific sort of characteristic of a deal or of a financial, a finance department or whatever. Sometimes you might not have the exact thing that's on the document request list. Again, I'm talking about this M&A sort of finance, audit kind of scenario. You might not have that actual thing that they're requesting, but you might have another sort of set of data that will give them the substantiation of that, right? Like another way to kind of, validate what it is they're looking for. Does that same sort of dynamic exist in managing these document requests, in the context of what we're talking about? And how important then is it for us or us in combination with our outside counsel to, know what we have available in the absence of the specific request? You understand what I'm asking? How do we kind of, if we have a better understanding, does that help to at least show as being more helpful or more sort of good faith in our collaboration with them during their investigation?
Yeah, absolutely. So just by way of example, and I think this ties to your M&A analogy pretty well. If I read a CID, my gut and my experiences from all the investigations I did in the DOJ give me a feel for what this investigation's about,
right,
and where it's likely headed, right? But I can be off base if I don't understand your business well, right?
Right.
And that is where you, on the compliance side, can bring so much value to me and tell me, okay, I think that's right, or I can help lead you even to a more specific area of inquiry. So it's not as broad as you might think in terms of this program. I think they're focused on this subsection of a program that we have going. But I think it is extremely critical. Leigha mentioned this earlier, that having counsel who have done these DOJ investigations from the inside is of real import, because they do come with that understanding. I was working on a matter that came in just the other day. I've received a CID. My client didn't have any idea what it was about. I was able to review it and give him a pretty good feel for where I thought they were headed. And he said, oh, that makes sense because this, and this. And so they're probably going to want these documents, and they'll show that this is not the case, right? So I think by putting those two things together, it's going to ultimately reduce cost and reduce the amount of time and energy you have to put into dealing with it on the compliance side.
I mean, there's some subjectivity in any kind of investigation, right? I mean, somebody's coming in from an outside organization into, a company, and they're trying to, they're trying to validate whether this thing they think might be going on is actually going on. So you're looking at data, right? You're looking at a bunch of objective things, but then there's also this whole layer of subjectivity that comes into, like, do these people know what they're talking about? Are my counterparts within the organization competent? Are they easy to do business with? Are they easy to work with, quote unquote? Are they giving me the information I need? And does there appear to be a good faith sort of effort in like remediating this potential issue? I think there's a lot more kind of power in some of those subjective things than some of us may think.
I am having trouble hearing you, Nick. I'm so sorry. Scott, are you?
Oh, I just said something brilliant. My gosh, too
it
bad.
was amazing,
Okay.
Nick. It was, yeah. No, of course there's a subjectivity, right? And when you're meeting with investigators or your counsel are meeting with investigators, credibility is key because they're going to evaluate, one, like you said, what is the competence of the organization? What is the competence of the people inside the organization? How forthcoming are they being, right? I'm not suggesting that you go in there and just tell them anything and everything they want to know from the outset, but are you honest in trying to address their questions? And at the same time, trying to be persuasive that, hey, there's nothing for you to see here. Let's close this up. That's a fine line that you have to walk. But if you have that competence and then integrity in your dealings with counsel, and then your compliance plans and any communications inside the organization also demonstrate a culture of the same type of approach and how you deal with things. Hey, we have a problem. Here's how we're going to deal with it. Hey, we have this whistleblower. Here's how we deal with them. We're going to hear them out. We're going to address their concerns. We're going to circle back and let them know that we hear them and we're addressing them. All of those things are going to impact how an investigator analyzes the evidence that they see in front of them, just like it would a jury. If you're sitting on a witness stand and you're testifying, that jury is evaluating you from top to bottom, from the way you walk up there to the words that you say and the ways that you say them as a witness, right? The same thing applies to investigators. They're going to form some type of, not conclusion, but ideas about how you likely deal with things. Are you trying to hide things? Does it appear that you're trying to bury stuff that
Right.
perhaps they should have? But the example that you gave where maybe you have some data that would answer the same questions, but it may not be directly responsive, but you think could actually further your goal of closing something out, would be tremendously helpful, I think, in helping the organization address investigator questions quickly.
Very good. How are we doing, Leigha? Can you hear me now?
Yes, totally. I don't know what happened. Good. I'm so sorry, Nick.
All good. All good. You can do no wrong with me. So you could actually get up and leave right now if you want, and I wouldn't even say a word.
No, I'll stay till the end.
All right, very good. So I have a question here about what kind of a role does the presence or absence of a quitam relator play in shaping DOJ's approach to doing an investigation? And does that have any impact on an organization's strategic response options? Like, does that actually set us on different paths? And do we need different responses in the absence or presence of that kind of relator?
You want me to take that, Leigha?
Yeah, he's the. In Texas, we pronounce it really weirdly, Nick. So forgive us, but we just.
Well, I can barely read, so maybe I'm saying it wrong. How am I supposed to say it?
No, you're saying it correctly.
But Scott is the quitam expert in our group, so I will let him talk about that.
So it does not shape how the DOJ is initially going to investigate the allegations. They are going to do the same things they would do in the absence of a quitam, as we say in Texas, or quitam lawsuit. But it does shape a lot of how you want to deal with it. So one of the things that your outside counsel is going to want to talk about with investigators is what we call the C2A, right? Which is a government's motion to dismiss the quitam before, and not allowing the relator to proceed. That is one of the biggest changes in dynamic when you have a whistleblower, is your case is not going away just because the government investigates the allegations and concludes that it does not want to intervene and litigate the suit. Unfortunately, the relator gets to continue to litigate that case through its end, And that's going to just continue to cost the company organizationally money, as well as the resources of providing witnesses, providing documents, provide all of those things, right? So you want to have someone who's going to go in and advocate to try to convince investigators that not only is what the relator's saying not have credibility or validity, but in addition, it is so off base that you should step in and dismiss this case and not force us to waste these resources litigating them going down the road. But how do you do that? A lot of counsel, in my experience, I had a lot of counsel who would come in and try to badmouth the relator. Tell me about how they were a terrible employee, tell me about how, I shouldn't listen to them. Whatever their weekend activities were really questionable, whatever the case may be. And I heard that so often that it was completely ineffective. It did not sway my thought process at all. Mm-hmm. I was focused on the elements of the allegations that they had charged. So I think when you're, as the compliance group, and you're working with counsel, you want to be focused on the elements of what they are investigating, what the causes of action that have been brought, right? And you want to disprove those. You want to show an AUSA, show a trial counsel from DOJ that this is a waste of your time. You don't have the resources to be putting into bad cases that are brought by relators where maybe they're just misinformed. Maybe they thought something was there that is in fact not there. That does happen. You want to try to attack those elements, show them that there's not anything for you to benefit from government by continuing to pursue this investigation. And then lastly, on the settlement side, I kind of alluded to this earlier, the government won't settle for nuisance value or quote, cost of doing business when you've got at any point, but especially when you've got a key TIM. And any settlement that you negotiate with the relator down the road is in fact subject to the approval of the government. So okay. Even if you're able to cut a deal with a relator, it's not necessarily going to settle your case. The government has to step in and bless off on your settlement, and they are not going to do that unless there is recovery for the government on a principled basis for the allegations that have been asserted. Otherwise, that litigation is going to continue forward until a judge, rules on it or you have a trial.
Okay, so for this last, thanks for that rundown. That was really, really clear and really well explained. So I want to talk a little bit. We have a couple of minutes left, and I want to talk about some proactive compliance strategy development questions. And I am always of the position that whenever there's change, that's opportunity for us. Like there's always opportunity in change, and with the changing scope and the changing focus on, healthcare fraud, as you said earlier in this episode, I think it creates some opportunities for compliance folks to, maybe engage with the business in some different ways. So I want to get, let's start with you, Leigha, and then we'll go to you, Scott. Like, how do you think compliance leaders can transform the potential for investigations or a potential investigation scenario into, opportunities to really demonstrate to the organization their commitment to integrity or to strengthen their strategic position within the company? How can we use some of these things that maybe we're not in an investigation or whatever yet, but how can we use some of the stuff we've been talking about today to really kind of strategically develop our program and push it forward?
So what Scott said about really understanding the business and what risk you have because of that, and combining that with this administration's priorities that we've discussed is a great way to proactively enlarge or change your compliance plan and your internal investigations plan to be ready before the government might come knocking. And one of the things I wanted to hit on that I just briefly mentioned before is an aspect that you may not think of, for example, is your DEA compliance, the DEA civil regulations in terms of controlled substances. If you manage a hospital system, if you manage physician groups like psychiatrists who deal a lot in opioids, that are prescribed, or doctors who deal with pain management issues. You are going to want that to be part of your compliance program. In fact, we, as an office, Scott actually led a major investigation into a giant hospital system here in Dallas and came away with a multi-million-dollar judgment because they had such lax controls on fentanyl that it caused some overdose deaths of nurses in that facility. Yeah, it was really bad. And so he did that, and he now does DEA compliance consulting for healthcare groups who are facing that. And we saw from the press release that is something they're really focusing on and part of their push on healthcare. And then the cybersecurity is another one where you really need to get some, you talk about what cybersecurity controls do you have? Do you ever provide anything to the government? Because that's part of how they can have civil liability. Your company can when it comes to lax cybersecurity controls. And I wanted to say, Nick, on that subject, I think next month you're going to be talking with the person in our group who is our cyber security expert. Because that is such a growing area in terms of compliance that we have added her. She's like a nationwide expert in it. She also came from our U.S. Attorney's Office. That kind of thing is important. You just got to look beyond your core, sort of what has always been a part of your compliance program, and just really think about where are our vulnerabilities right now.
Great. That's really great. What would you add, Scott?
Just very briefly, when you can, everyone's resources are stretched. Everyone's expected to do more with less. So if you can offer, trainings or assistance like during the lunch hour to a specific group, and you can say, this is not about me. I want to protect your people. I want to protect you. Right. Just give me 45 minutes of y'all's lunch hour. Let's see if we can just brown bag it. Anytime you can do that, folks are more inclined to say yes than whenever you put out a mandatory training announcement, right? Everyone groans. They roll their eyes. We all know that, but yet we all need them. But to the extent that you can tailor some specific trainings that would be applicable to a group and maybe a business segment that they are working, I think it's likely to be better received.
Well, yeah, you have some control over the messaging. You have a much higher odds of that message getting delivered in the right way. Yep. And you can get some more touch points with a wider audience whose connection to your risk management apparatus is absolutely critical. What we're kind of talking about. Sorry, we're running over. Not that sorry, but this is worth it. I come from the M&A world, and in any deal, you're building a financial model that's a bunch of projections for the future. And part of the underwriting process is doing what's called like shocking the model. Like, okay, what if growth totally falls off? What if our, time to get cash in the door totally changes and that doubles? Like, what does that end up doing to our financial covenants and so forth? So that kind of exercise of like shocking a model can do a lot if we applied that mentality, kind of to Leigha's point, to whatever risk management apparatus we're running. So the scope is expanding. There's a different focus from on the federal level. There's different things that maybe, we would need to have in place today that we didn't need 4 or 5 years ago when maybe, the structure for this risk management apparatus was first, constructed. So kind of going through that mental exercise, that mental, simulation of shocking your model, so to speak, can give you some real hints on like, hey, if we get pinched for this thing, we don't have a lot of like good evidence to point to. We should probably spend some time kind of bolstering that thing. Like, you can't do everything ever, right? Like, nobody has a to-do list that like actually gets done. So then it really comes down to like, are we making the right bets with our time that are going to mitigate the most risk? It's a constant flywheel of like reassessing what we have in place, what the most likely gaps are, and what are the things that, should we shock the model, are going to have the biggest fallout. So anyways, I always love having you guys on. You guys, I had really high expectations for today. You guys blew by it. So I need to like raise my bar of expectations a little bit more. If you folks have not connected with Leigha and Scott, their LinkedIn should be on the console. We got to have you guys back soon. Thank you guys so much. Let's get one more massive emoji explosion, one more massive round of applause for Scott and Leigha.
Oh, thank you so much, Nick. It was so fun to be on the show today.
You guys are awesome. All right, we'll see you guys this Thursday. We're talking about risk assessment implementation, the biggest risk there is. So please join us then. Bring your friends, and we'll see you soon.